Um, Hi everyone, this is Aditi, and today we'll be talking about very important topic, which is law of contracts. Now, this lecture is scheduled only for you to know the concepts, like the basic concepts about what exactly a contract is, how contracts are made, what kind of contracts are there. So, we're going to be starting with the lecture, and this is a very simple PPT that I've made, and I hope that I think this will help you with your preparation. So as we all know that now CLAT examination has made the paper very subjective. Subjective as in context to the syllabus. The syllabus is not defined when it comes to legal area. So definitely this topic is going to help you to understand what that law is, and by chance we get an article or a passage which is talking about a law of contracts or a contractual relationship between two individuals, then I think this will save a lot of your time to when you like to interpret what kind of this topic is. So let's just begin. And this topic will also help you with other various law entrance examinations, for instance, AILET or SLAT, because the pattern still remains the same there. So let's just start. So these are like the basic preliminary points that we have to look into, which is some factual questions that might come up. Uh, पहला तो हो गया इंडियन कॉन्ट्रैक्ट एक्ट कब इन्फोर्स हुआ था या कब फोर्स में आया था. इट वाज इन on 1st September 1872. Then the second point talks about what was the first case instituted under the Indian Contract Act. So it was Madhup Chander versus Rajkumar. It was in 1874. 2 years later, the enforcement of the act. This case was enacted in Calcutta High Court. Then this Indian Contract Act, since it's a pre-independence law, that is, this law was not created before, not created after independence. Rather, it was created before independence. It's a contract which is adopted by the British rule. So here, this validity is derived from two sections of the Indian Constitution. That is 372 Clause A, which talks about the powers of the president, and Article 13(1), that is laws which are inconsistent or in derogation with the fundamental rights. So if you just want to read these articles, you might read in your Bare Act, but I think it's very much easy to interpret what these articles says. So you can Google it out and read about them. Rather, it's not very important. Then again, Sir James was behind the Indian Evidence Act and Indian Contract Act. Basically, it's a British law that is adopted. So definitely, the Britisher was Sir James Stephen. Then we talk about the Indian Contract Act 1872. It does not create rights and duties. So when you look into the act, it does not talks about an individual's rights or the duties. Rather, it talks about what are the conditions or the rights or duties that two individual parties come on a mutual consent to get into a contract or an agreement. How those rights can be enforced, what those rights should be, what is a valid contract. Hence, that is the reason why it is right in personam and not right in rem. Contractual acts are right in personam because it deals with person to person, that is two parties, three parties, multiple parties. But right in rem, the acts such as Indian Penal Code, CRPC, basically the criminal laws, Indian Evidence Act, it talks about right in rem because it talks about all the people who are present in the society, right? So this is a very essential element of Indian Contract Act. Then this law tells us about how an offer is made when it is said to be accepted and what is the consideration behind it. So all these things, the offer, acceptance, consideration, we are going to talk about these aspects in a coming slide. So let's just go ahead. So this is James Stephens, if you are eager to know who he is and what he looks like. So this is the guy. Then types of contract. So here there's this table which talks about on three bases the types of contracts have been bifurcated. First is on the basis of validity and enforcement. Like when initially a contract is put forth in front of you or a situation is put forth in front of you, the only thing that you have to assess is it a contract or not? And if it is a contract, what kind of a contract is it? It should be a valid contract to be called as a contract. So is it a valid contract? Is it a void contract? Is it a voidable contract? Is it an illegal contract? Or is it unenforceable contract? So validity and enforceability is very important. That is why the first subpart is talking about the validity. That if the contract itself is not valid, all the other essentials that is mentioned in B and C automatically is not important. So the first look when you give to your question, you have to decide about the validity and enforceability of the contract. So as I've mentioned, these are 5 types of contract in part A. Then part B, on the basis of formation, it talks about express contract, implied contract, quasi contract, e-contract. Quasi and e-contract are not very much important these days, so let's just not consider it much. We're not going to read about it. Express and implied is very much asked in the examination prospect, so that's the only thing that we have to consider. Talking about the third part, on the basis of performance, executed contract, executory contract, unilateral contract, and bilateral contract, which is in the executory contract aspect. So again, on the basis of performance, it's hardly asked. So the only thing that you have to consider is on the basis of validity and enforcement and on the basis of formation. So you have to keep in mind these two aspects only for the law entrance examination purpose. Otherwise, if you're keen to know about these type of contract, you can read about them. Then let's just go with the types of contracts further. So type of contract, the first and very important aspect of contract is that it should be a valid contract. Now, what is a valid contract? Valid contract is written or expressed agreement between two parties to provide a product or a service. For instance, I'll give you an example. There is person A who has, who rents house, and the person B is a person who wants to take a house for rent from person A. So they both come to a mutual agreement. They come to a mutual consent that yes, I want to give the house, yes, I want to rent the house, and they both come to a very mutual agreement, which then further is enforced by law, is known as a contract. And it is a valid contract because it is enforceable in the eyes of law. It is very much valid. No illegal activities involved, so definitely it's a valid contract. Here, that should be written or expressed agreement. So written agreement as in it should be written between both the individuals. What are the terms and conditions? Yes, I want to buy the house. Yes, I don't want to rent the house. Whatever that has to be mentioned has to be written here. So this is a valid contract. So definitely here a product or a service is being provided. Service is rental service or product is the house. So this is the main ground. Here there is a valid consideration as well. All right. We're not going to talk about consideration aspect now. We just have to look into the validity of the contract. So here the example that I've given is absolutely a valid contract because it is enforced by law. It is allowed by law to rent houses. What are the terms and conditions that has to be between two parties to provide a product or a service? Here the product or the service is the rent, the house that has to be delivered to B. Talking about the next aspect is void contract. Now, what is a void contract? Void contract cannot be enforced by law. Very naturally, a void contract, for example, a contract between, here the example is already mentioned, a contract between drug dealer, buyer is a void contract simply because the terms of the contract are illegal. So as I said, if it is not enforceable by law, it is a void contract. If it is enforceable by law and it is not illegal in the eyes of law, it is a valid contract, right? In such case, either party can go to court to enforce the contract. neither of the parties can go to the court. So definitely, on what grounds you will approach the court will dismiss the petition then and there itself, because it is illegal and it is not enforceable in the eyes of law. Third point that we're talking about is voidable contract. Now, it is not like void contract. Uh, it is a valid contract which may be either affirmed or rejected at the option of one party. At most, one party to the contract is bound. The unbound party may repudiate or reject the contract at which time the contract becomes void. Now, here in voidable type of contract, it is not a void contract. Rather, the contract can be held valid if it is affirmed by one party, and it can be made a void contract if it is rejected on the option of the other parties. So if one party who is bound by the contract and the unbound party uh, can actually make it a void contract if he rejects it. But the party who is bound by the contract can make it valid also, because there is no rejection or repudiation on the part of the unbound party. So here, the voidable contract becomes a valid contract on the basis, rejection or acceptance on the basis of the second party who is not bound, right? So this is this type of contract usually makes students a little uncomfortable or confused. So don't worry, we'll be releasing practice questions, practice sessions on these kind of contracts, and when you approach the questions, I think you will be very much able to understand what it is. So let's just go ahead. Illegal contract. Now, illegal contract is an agreement that violates the law because its fulfillment requires the party to engage in illegal activity. Such a contract is void and unenforceable from the get-go, that is, from the beginning. Thus, if the contract is breached, neither party will be entitled to any compensation or held liable. So, for instance, if there is an illegal contract of for instance, I come in contract with uh, Amazon. And Amazon, in his agreement, in its agreement, mentions that I have to go and kill Mr. Bill Gates only and only then I'll be paid uh, for the services that I've provided to Amazon. Here, this example is a perfect example of an illegal contract because the terms and conditions forces me to get into a contract or get into a situation which is not enforceable by law. These terms and conditions won't be accepted, and hence it makes it an illegal contract because the terms and conditions are illegal in its nature, and it is compelling me to fulfill certain activities or engage in illegal activities which are not regulated by law. Obviously, murder is not a valid ground by law. So this is a perfect example of a legal contract. Second is unenforceable contracts. Now, as we all know, enforceable contracts are those which are valid in the eyes of law, and hence when you go to court, you can obviously make it enforceable. Unenforceable contracts or transaction is one that is valid, but on the court will not enforce it. For instance, there are a lot of agreements which are not necessary to be notarized. Okay, if there's an agreement between two people, it is not important to get that agreement notarized by law or by the court. So if the parties perform the agreement, it will be valid, but the court will not compel them if they do not. So these are unenforceable contracts. For instance, an agreement which is not enforced by law. So definitely it falls in unenforceable contract, because when you go with an agreement to the court will not be able to enforce it because obviously it is not enforced in the eyes of law yet. So if they perform the agreement, then it's a valid contract. But if they do not perform it, then the court can never compel them to do the same activity, right? So let's just go ahead. Implied contract. Now, this comes to the second part of the types of contract. Implied contract talks about it is created when two or more parties have no written contract, but the law creates an obligation in the interest of fairness based on parties' conduct and circumstances. So if there is an implied concept behind a contract, which obviously means that if I am going to a restaurant, I'm paying for the food, which talks about fresh parsley leaves in it. And definitely, if the parsley leaves are not fresh, then I can sue them. It's an implied contract that when you're selling fresh parsley leaves sandwich or a roll, then it definitely should have fresh leaves and not the uh, old ones. So this is an implied contract. Then express contract talks about those terms and conditions which are explicitly written in the contract. Like an express contract is a contract whose terms the parties have explicitly set out. This is also termed as a special contract. In an express contract, all the elements would be specifically stated. In an express contract, the agreement of the parties is expressed in words, either oral or written form. So if you want something out of a contractual relationships, you have to expressly mention it in your written format or the written agreement, or you have to orally speak it out. Otherwise, that contract will not hold those terms and conditions valid, because after the contract is drafted and signed, then you come up with another condition or a term. It is definitely not expressed in your contract, and hence that term will be nullified from your contract. So yep. Then important definitions and elements of a contract. So here we talk about offer. Now as you can see, I've mentioned the section is not very important, to be honest, because लॉ एंड लेवल पे इतना डिटेल में पूछते नहीं है. बट व्हाट इज एन ऑफर इज मेंशन्ड इन सेक्शन 2A. These kind of questions are mostly asked by NLU Delhi because they want to stand out in every aspect, so they do get into technicalities and details. So you may keep it in your subconscious mind that it talks about section 2 is there. So section 2 talks about when a person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of the other to such act or abstinence, he is said to make a proposal. For instance, I go to the Reliance or I go to person B. Let's talk about person B. I go to him and I tell him that, listen, I actually want to buy your car. So can you sell me your vehicle? So this is an offer. This is a proposal to person B, because here I have signified my willingness to do something in a view to obtain his assent, his approval. Then I have made a proposal. I asked him, can I buy your vehicle? Definitely, because I want his assent. I want him to say yes. So I have proposed to him, right? So this is a proposal. What is an acceptance? Definitely it talks, section 2B talks about acceptance, and it is when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So when I made the proposal, hey, I really wanted to buy your vehicle, and the other person, that is person B, says, yeah, sure, you should buy it, and definitely I'm up for it. So this is known as an acceptance. It's a valid acceptance because the proposal that I've made to has been accepted by the individual. So also another important thing, whatever I have proposed, that has to be accepted. If there is another terms and conditions attached with the acceptance, it is a counter offer. All right. So for instance, I said that I really want to buy your blue vehicle, but can you are you up for it? So the other person says, yeah, I'm up for it, but definitely I cannot sell it for 4,000. So my condition is that I will only sell it for 1 lakh. So this kind of a proposal is a counter proposal or a counter offer. Now, don't bug me in the comment section that the individual who was proposing wants to sell it for 4,000, but it's just an example, so don't, relax. So further we go to promise. Okay, promise is according to this section, that is section 2B. Promise is a proposal when accepted becomes a promise. Definitely proposal plus acceptance is equals to promise. So I said, can you buy me? The other said, yeah, you can definitely, I'll definitely buy you this vehicle. So that is a promise now. The conversation between two people where acceptance and proposal is involved. So a proposal when made to someone, the said person accepts, then the proposal becomes a promise. Okay. Now, what is an agreement? Now, the only thing that you have to consider while considering agreement is a valid agreement or not. That is, there is meeting of minds or a mutual understanding between two people about their reciprocal rights and duties regarding past or future performances. So agreement is created by parties, even two people who are, there are rental agreements, builder-buyer agreement. So these agreements are created by the parties who are involved in this contractual relationship. So that's an agreement. Okay, another important thing that I want to talk about is when an agreement becomes a contract. An agreement becomes a contract when an agreement is enforced by law, it becomes a contract. So an agreement without enforced by law is just an agreement, but the moment it is enforced by law, or there's a legal angle is added to the agreement, then that agreement becomes the contract. So, okay, again, the second slide talks about what is contract. So here, section 2H talks about an agreement enforceable by law is a contract, and a contract is created by law. All right, so section 10, here these are sections which I'm just reading it out, you just have to listen to it. There's nothing that you have to memorize that which section talks about what, but you should have a vague idea. Okay, so what agreements are contracts? Now, what kind of an agreements are known as contracts? So all agreements are contract if they are made by free consent of the parties competent to contract for a lawful consideration with a lawful object and are not hereby expressly declared to be void. So basically, when we talk about section 10 talks about lawful consideration. Okay, so if I say that I have a chartered plane and I want to sell it for 1 rupee, it's not a lawful consideration. I mean, it's not a lawful consideration as it is not variable to the amount of the service or the product that I'm providing. Or lawful consideration, unlawful consideration can be, I'm going to give this to you, but you have to steal that much amount from the bank. So it's not a lawful consideration. Consideration is the ground or the amount or the thing on which the whole agreement is set to. So there should be a lawful object, that is to buy the vehicle, to buy the house, to rent a house. These are lawful objects. That is the ultimate goal of the contract. And unlawful objects are to kill that person. There's an agreement between two individuals or a contract signed between two individuals that, we have to kill third person. So these all things talks about lawful consideration and lawful object. Then free consent of the parties, definitely गन पॉइंट पे रखे किसी को नहीं agreement में ला सकते हैं या contracts में ला सकते हैं. उसका free consent, उसका individual consent होना बहुत जरूरी है. Second point that we're talking about is a pertinent point here is that the contract does not get void. It is always the agreement that gets void. A contract is void only under one circumstance, that is frustration of contract, which is given in section 56 of the Act. Now, this is not important, but mostly जो कुछ questions होता है उसमें वो बोल देते हैं, can an agreement be void or a contract be void? So both are correct, both are wrong, one is correct, one wrong. These kind of questions are usually asked in AILET. So you can read it and keep this in the back of your head that, okay, only contracts can get void. Only agreements can get void. Contracts can get void only in one circumstance, when there is frustration of contract, which is mentioned in section 56 of the Act. So this is all